Agents' obligations in respect of building and pest inspection reports. That's what we're going to be talking about in this presentation. Now, although that might seem fairly straightforward, I have had a number of agents of late querying or questioning the clarity around what are their obligations as a selling agent of residential property in respect of building and pest reports. Now, the first thing to note that at this particular point in time, there is no obligation in New South Wales for a contract for the sale of residential property to have in it a pest and or building report, as it is the case in other jurisdictions. So at this point in time, the vendor does not have to include that in their contract. However, Clause 33A of the Property and Stock Agents Regulation 2014, the current set of regulations, does have a provision in it that came into force on the 15th of August 2016. So it's not necessarily a new provision, but it's a provision that probably hasn't received a lot of attention, and so we're going to be sort of digging into it a little bit. So from August 2016 onwards, under Clause 33A of the regulations, it states quite clearly that an agent selling a property, an agent working for a vendor's agent, is required to keep written records of reports that they become aware of in the process of selling that property, so that those details can be passed on to prospective purchasers. And the regulation goes on and stipulates quite clearly what sorts of reports are captured by Clause 33A. As you'd expect, they include building reports, pest reports. They also include those what are generally called strata reports, so reports that are done under Section 80, 182 and 184 of the Strata Schemes Management Act, as well as Section 26 of the Community Lands Management Act. So those reports that are often requested by buyers when they're buying strata property or community title property. So there's broadly speaking, building reports, pest reports, and, for want of a better term, strata reports. Those reports, if the selling agent is aware of that report or is aware that it has been commissioned or asked for, then they do have an obligation to keep written records and to pass those details on to prospective purchasers. Now, the obligation to pass on those details to prospective purchasers relies on the fact that the prospective purchaser has asked for a copy of the contract from the agent for the sale of residential property. Now, you're probably aware that under Section 63 of the Property and Stock Agents Act, there is an obligation that the sale of residential property cannot begin, you cannot market a property at all in any way unless the agent in question has a full draft copy of the contract available in their office for review by prospective purchasers. So in a way, Section 63 of the Act and Clause 33A of the regulations complement each other, because the requirements for passing on details of building and pest reports and so forth relies on the prospective purchaser requesting a contract. Then the obligation of the agent is triggered. The agent then would need to pass on the details of these reports which they've collected. And interestingly enough, it doesn't matter that the prospective purchaser has asked for the details of these reports or not. The agent must, if the prospective purchaser has asked for a copy of the contract, must also provide those details of the reports that they have gathered to that prospective purchaser, whether they ask for it or not. If the prospective purchaser has not asked for a copy of the contract, but has asked for a copy or the details of these reports, the agent is under no obligation to pass those details on. Of course, that would be left to the discretion of the agent. Obviously, in many cases, why wouldn't the agent pass on the details of these reports, even though the purchaser, the prospective purchaser, has not asked for a copy of the contract. So those details should be fairly well understood. Now, in addition to what type of report must you capture the details of, there's an obligation also to capture certain details. So you'd be right in assuming that you need to capture the basic details. The sorts of details that we're after here is the date on which the property was inspected or the documents were inspected in the case of a strata report. Who requested the report, whether it's the vendor, the vendor's agent, the prospective purchaser, who was the party or company or person who did the report, the commercial details of that party. The fourth element they need you to capture is whether or not that property report is available for resale. And the fifth element that you need to capture in your paperwork is whether or not that provider of the report, let's say the pest inspecting company or pest inspecting person, whether that entity has professional indemnity cover or not. Those 5 elements is essentially the record that you need to keep, and that must be passed on to prospective purchasers as noted. Now, keep in mind that this obligation to pass on details is a once-in-time obligation. So the purchaser calls for a copy of the contract, you make it available, and you provide that person with the details of the reports you've captured thus far, and you do not have to then follow up with subsequent reports that you become aware of. Obviously, a good agent may well want to keep on informing a genuine prospective purchaser, even though there is no obligation to do so. Keep in mind that there are fines for non-compliance, $2,200 up to $4,400 for a company. And it's worth noting that there are lots of companies out there who have responded to this legislation and who provide products that meet these requirements. So keep an eye out for those providers. The final point worth noting here is just a quick conversation around how does an agent become aware? To what extent must an agent make efforts to find out about reports and then capture details of them? So the legislation just requires an agent to use reasonable efforts. Asking the vendor or the vendor telling you capture that information. If you're aware that a contractor, a pest and building contractor, is contacting you for access, make a note. If you're aware of a purchaser who has ordered or got a report, you then capture those details. So you're not required to exhaust your efforts. You're required to use reasonable efforts to make this record. And the final point I want to convey to you is that the agent who captures the information creates the report under the requirements of Clause 33A of the regulations, is not liable, obviously, for the content and the accuracy of the information in those reports. You are simply providing information to prospective purchasers that you become aware of on reasonable grounds. My name is Craig Swan. I hope that information has been useful for you. I would always welcome and encourage any feedback or comments. You can reach me through Instagram, Craig_Leverage Group. You can reach me through email, Craig Swan, SWAN, at leveragegroup.com.au. I wish you all the best with your endeavors in the world of agency. Stay safe, and as usual, happy hunting.